it for now.
Okay, so let's go into the next section. I'll talk about evidence and preparation for the hearing. So now we understand how the hearing actually works and how credibility is assessed. And we need to talk about something more critical: how to prepare your evidence, your testimony, your documents, and your mindset for the hearing. Most refugee cases fail not because the story is false, but because the claimant was not properly prepared. The claimant forgot details, contradicted their basis of claim, and didn't understand the documents, or perhaps they were overwhelmed during the questioning. So, knowing your case, preparation begins with mastering your own evidence. Your basis of claim is the foundation of your claim. At the hearing, the member often has your basis of claim open right in front of them. So common problems will include forgetting dates, forgetting what was written months ago, and the confusion about the sequence, omissions or contradictions, and changes to your story without explanation. Before the hearing, you must read your basis of claim again and again. You must understand every date, every place, every event. You must identify the areas where you need clarification, and you must discuss any inconsistencies with your lawyer if you find one before the hearing. So remember, the member is comparing every word you speak to your basis of claim. So know your supporting documents. Supporting documents includes police reports, medical reports, the threat messages, photographs, letters from witnesses, sworn statements, media articles, country condition reports, psychological reports, medical reports, and religious community letters. For each document, you must understand who wrote it, when it was written, why it was written, and how that evidence supports your claim. Many claimants submit documents they never read. At the hearing, the member may ask you, when did this letter writer meet you? Or how did you obtain these documents? Why did this report not mention this important detail? You must know your documents very well. And then you must know the country condition evidence. It's crucial because it shows why the harm you fear is real and how people like you are treated in your country, and whether state protection exists for people like you, and also whether internal relocation within your country is going to be realistic. So, for example, LGBT claimants should know the laws that criminalize homosexuality, the patterns of police violence, the community-based discrimination they will suffer based on their sexual orientation, vigilante evidence, and the barriers to living openly. Gender-based violent claimants, on the other hand, they should know the cultural norms in their country. You should also know the police inaction, the stigma, the patterns of impunity. So reading the country evidence, it gives you confidence and ensures your testimony aligns with real world conditions in your country. So preparing for your testimony, this is where many claimants struggle because they have lived the experiences, but they have never had to explain those experiences clearly and linearly. So you have to practice answering the questions directly. There's a difference between telling your story freely and answering questions under examination. So when you're asked, why did you not report to the police? Your answer structure should be a direct answer. I did not report because I was afraid they will harm me or they will expose me. Then brief explanation. Oh, in my community, the police are known to arrest people like me instead of helping. So I have friends. You can provide an optional context like, oh, I have friends who were also victimized after reporting. So do not launch into long stories. Long answers can create contradictions. Understand the key events. For every major event in your claim, you should know what happened, where it happened, when it happened, who was involved, why it happened, how it affected you, and what you did afterwards. So this helps the member to see your story as coherent and truthful. So you can also manage your trauma during testimony because trauma affects memory, emotion, your clarity, your sequencing, and your concentration. So during the hearing, you have to ask for breaks when needed. You have to breathe before answering. Do not rush. Ask for questions to be repeated to you and then use grounding techniques like have deep breaths. At some point, have deep breaths, and then if your claim involves trauma-based harm, sexual assault, domestic violence, and persecution based on gender identity, so the guidelines, like I mentioned before, are powerful tools that the member will assess your evidence and your testimony with. It's your responsibility to explain contradictions. So contradictions happen especially when the claims were filed in crisis, or when previous counsel made mistakes, or where there was a lack of proper representation, there were interpretation issues, or where trauma really impacted your memory, and when you are too afraid to disclose everything. So the key thing here at this point is you acknowledge the issue, you take responsibility. You have to take responsibility for any contradiction or any mistake you make in your case. And then you provide a logical explanation, and then you stay calm. You don't have to argue with the member. So for example, you understand the dates appear inconsistent. At the time you prepared your basis of claim, you are traumatized, you are confused. Honesty is powerful. Honesty is very powerful. Members respond well to people who take responsibility and people who are honest. So, what documents do you need? What type of documents are helpful? You must provide documents that support your identity. Your identity is the first issue. In order for your refugee claim to be accepted, the refugee board must make a finding on a balance of probabilities that your identity has been established, your personal identity and your national identity. So you bring documents that support your identity. You bring documents that confirm the harm that you face if you return back to your country. Documents that show the real threats and connect you to events or group, and also you confirm the medical or psychological impacts. You can also provide documents that show police inaction or persecution. You highlight the discrimination or stigma, and then it has to be consistent with the country conditions. So remember, not all documents are required. Some claimants cannot get documents due to danger, and the IRB knows that already. So how do you obtain these letters of support? Um, the letters must be specific. The letters must be written by someone who has first-hand knowledge. That's who you're going to contact to provide a letter of support. The person has the first-hand knowledge of the events that happened. You must include the contact information. They must explain how they know you, and they must avoid copying your basis of claim. They must write in their own words, describe the events in their own words, and they must be realistic and humble. So a good letter answers the question of what they know about the case, how they know it, and why they believe you're in danger. So the IRB will reject generic and exaggerated letters that just talk about general things. Such evidence will not be helpful for your case. And then avoid submitting documents late. Late disclosure applications are usually stressful, and at the beginning of the hearing, the member will try to dispense with any issues concerning late disclosure, and it can set the tone for the hearing. So if you're at the point of hearing, you're bringing in documents late, be rest assured that the document will be scrutinized properly by the member, and be prepared to provide answers to questions about why this document was not available. You had all the time since you submitted your claim to make your documents ready. Why were you unable to provide that document until the morning of the hearing? You have to be ready to answer that question, and it's not a good position to put